Georgia lawyers Bob and Irreverent D talk law. Listen up for stories about how things really happen in our legal system. On today's episode, Bob and Irreverent D dip into the mailbag to answer your criminal defense questions. Now, sit back and take a listen as Bob and Irreverent D talk law.
All right, welcome to the Bob and Irreverent D Talk Law podcast. I am Bob, or Benjamin O. Benson, and I am joined, as always, by the illustrious, the immutable, the not irrelevant, Irreverent D.
You're too kind, my
Dwayne
friend.
Singleton.
Too kind.
How are you doing today?
Man, got a little headache here today, but we're here. We're doing it.
We're getting it done.
Because we gotta get the work in. We gotta do the grind.
Listen, it's all about making sure that every day you just do a little something. You show up.
A little more.
And you do just a little bit more, just slightly more than you did yesterday.
Or figure out how to be a little more efficient than you were the day before. Right.
That's right. Well, today we're going to be doing rapid fire questions to a lawyer.
All right.
And we have a list of frequently asked questions.
Did we get a special guest to ask questions?
We did not. We don't have an 8-year-old.
All right.
We have the resident 50-year-old who's going to be asking you questions. And so we're going to go through it rapid fire. These are all the questions that a client, either if they have a criminal case or they have a family case, that they want to know, like from a criminal defense attorney, these are questions that are almost always asked.
These are like the front desk questions, the questions you get every day, over and over, time and time again. Which, by the way, happy birthday.
Yeah, thanks.
You hit 50 a little bit before me. I'm coming right behind you.
Are you coming right behind us?
It's coming up.
The real big milestone was the 10-year anniversary of the firm.
Which, congratulations.
It's a big thing. People asked me, or people congratulated 10 years ago when I started my own practice.
Right.
They're like, congratulations. I'm like, hey, slow down.
Let's see if we can keep this thing open.
It's easy to open your own practice. It's hard to stay alive.
Hang out a shingle out there and I'm a lawyer.
Yeah, right.
And then sit and stare at the phone.
All right. So you've never seen these questions before.
All right. Let's do it.
These are the questions.
It's time to dip into the mailbag.
Should our criminal justice system be more punitive or rehabilitative? Wait, come on. That's not a question that your front desk gets. All right. I'm going to rephrase the question.
Sure.
Look, if the point of prosecuting is to stop people from doing crimes, right? Should they really be coming after me really hard or encouraging me to be a better person?
I don't know if that's necessarily the point anymore. I think it's a big system now that's financed and paid for and definitely generates revenue. Very little is done as far as rehabilitation. It's mostly punitive. It's mostly just to punish people.
What would be an example of rehabilitation?
I mean, there are some, and we have a program in Spalding County. We have a drug court program. We have a veterans court program, which actually does meetings once a week, and they have to be drug tested, and they go through counseling. And I see those programs are very successful. But if you get sent off just to prison, there may be some aspects there, but most of it is just punishment. You're just there to serve your time, hopefully survive it, and get out. And most of the time, I see people come out of prison worse than they went in. They learn more skills. They come out with mental health issues. There's very little rehabilitative services to it. And we've done away with a lot of anything to do with mental health. We've closed a lot of those centers down. It's very hard to get people into mental health treatment. It's really more punishment. But yes, it should be about treatment. We should be trying to solve the problem. The fact that crime continues to go up should tell you that we're not fixing it. We're just, putting a Band-Aid over it.
Yeah, it's interesting. When we went to law school, we went through the criminal law class that outlined this whole theoretical understanding or philosophy behind crime and punishment.
You know,
right,
where they used to lock them in the things and preach to them all day, and hopefully,
right.
right,
And that was the dividing line, right? Is, are we doing this to rehabilitate the person, or are we doing it to punish the person? So as if we punish the person, other people look at it and see, oh, this person got punished, maybe I shouldn't do that, right? Like, oh, but what was missing. Now that I'm looking back at that from 25 years later, right? What was missing is the very practical theory, which is, no, we just don't want those people that are committing those crimes in our society. Just exclude them.
And you see a lot of judges now, especially in smaller towns, banishment is one of the big things.
Really?
Yes.
They're doing that?
Absolutely. So you're banished. Do you have any reason to come back to this county? No. Okay, you're banished from this circuit forever,
I didn't realize that's still a thing.
Oh, yeah, all the time. And so they'll banish them from the circuit, so they don't even want them back here. You stay up in Atlanta. Don't come back down here to east, wherever I'm at down here.
Interesting.
Right?
Yeah. But I mean, like, why isn't that part of our national, of our discourse? Like, maybe the whole point of putting criminals behind bars is just so that you stay there and stay away from the normal people.
Because countries that do really focus on rehabilitation get a bad rap because they're like, look at this prison where this guy is serving life sentence. He's got a television. He's got counseling. He can go on walks through that's not what should happen to somebody who commits a crime. We should punish them.
Yeah.
But especially for nonviolent stuff, and drugs is one of the big things, especially drug possession. Oh, this is your third time you've been caught possession of drugs. We're going to give you X amount of years in jail because you've got so much on you or whatever. It's because they're an addict, right? And they've never had access to any treatment. But people don't get excited about, let's treat them.
Right.
Right? They get excited about, let's punish them because, that's scary. People breaking in your house, stealing stuff because they're trying to support a drug habit. We got to lock them away forever. But I don't necessarily think that fixes the problem.
All right. Now, this next question, I do believe, is asked by many clients. Why do I have to go to so many court dates?
I always tell people that the process is part of the punishment, especially in criminal defense. Right. Because when we had COVID and we could appear virtually and send in an email and say we were ready, it was so much more efficient. But now we're back to, you've got calendar calls that you have to go to. You got motion hearings. You got a calendar on that. And then there's just such a backlog of cases that you can't hear all the motions on that day. You can't hear all the cases on that day. So if you really want a trial, you may go to 3, 4, 5 calendar calls, which that could be 1 or 2 or even 3 years that you're going to court. And people get so frustrated because they're like, Dwayne, I've changed my life. Why do they still want me to go to prison for 10 years? I'm like, because you did this 4 years ago. Right? And they can't have in the paper that they gave you straight probation or they dismissed your case because you were charged with, burglary, and it's a serious crime. And so they want you to do the 10 years in prison.
So does now, are there other things that go into the repeating of court dates? Like for example, your schedule?
Yeah. Well, look at the YSL trial where those attorneys have been not allowed to go to court on any of their other cases for almost a year now because they have a continuing conflict. They'd have to file a conflict letter saying, I can't be here, Judge, because I'm appearing in Atlanta on this trial that I've been sitting in for the last year. So all of their other cases are basically on hold until they finish that. And I've seen those lawyers, cases all over the state where the judge is like, is that trial still going on in Atlanta? And they're like, when's it ever going to be over? And everybody laughs, it's the longest running trial ever, Judge. And so you have to file a letter telling the court where you're going to be. And then the courts prioritize the cases based on age of the case. And then certain judges can say, no, he's going to come to my court for my case first. And it's kind of funny because we have a judge just recently where one of the judges and another judge in another county were fighting with each other on who was going to get us first.
Oh, gosh.
Yeah, because the cases were very similar in time and age. And they're like, no, he's coming here for this rape case. No, he's coming here for this murder case.
We need him here. Yeah.
Right.
Yeah. So let's just assume that there are no conflicts.
Okay.
All right. What's the minimum number of court appearances a person would have to have if they had a simple thing like possession of marijuana?
Okay. Possession of marijuana, if it's like in a city case, your first appearance is going to be your arraignment, just where you go and plead guilty or not guilty. Then you're going to come.
One.
That's one. And then you could come back for a bench trial if you want to do a bench trial and be there in 2. That would be the quickest on something simple like that.
A bench trial means that the judge is going to make the decision.
But let's say that I've got a marijuana case and I've bound it up to Superior Court because I want to fight about the issues with the THC and I want to have motions and I want to have a jury trial. Okay.
All right. So you can't do any motions or anything like that in little city court.
You can, but a lot of times when you file those motions, the prosecutor will bind the case up.
Okay.
He'll be like, no,
we're not going to
do all that here.
And what does bind the case up mean?
It means that he will bind it up from that lower city court up to either a state court or a superior court, just the higher court.
The higher court to handle it. Because ordinarily, if it's a misdemeanor marijuana thing, a city, it would just be like a traffic citation.
Right. And a lot of times your punishment's a little less in city court and your fines will be a little less in city court. So there are some advantages to taking care of the case. And in like a city court, you could reduce it to an ordinance violation, whereas in Superior Court, you wouldn't have that option.
You wouldn't have that option.
Right.
Okay.
Yeah.
All right. So you got the arraignment. You've got
your calendar call normally.
Right.
And then motions hearings would be in most cases. You'd have a motions hearing. And then you'd have a jury trial calendar call. And then you could sit on that jury trial calendar call. You could come 3 or 4 times. And then judges that really want to be assholes will make your client, they'll release the attorney and they'll say, but I want them here just in case we get to your case, and they'll make the client sit there all week, just to punish them.
Okay. And so that's what brings up the next question,
Right.
Which is, well, why does my lawyer's office say that it's fine for my lawyer not to be there,
right.
but the judge is making a big deal about it?
Because some judges are just that way, especially judges that went straight on a prosecution track.
Mm-hmm.
They were at the DA's office, and then they went straight to being a judge. They never were a criminal defense attorney. They never had to deal with clients. They really feel like you need to come in here, take your guilty plea. If not, you're going to sit here until we try your case.
You're just sitting here.
And what they're hoping for is that you miss a court date, or you come back 2 hours late from lunch, or you leave early one day, because some judges will even call the calendar again at the end of the day to make sure everybody's there. And they'll issue bench warrants for everybody that took off. Then they can lock you up and hold you in jail. And then that 3 years probation looks pretty good, compared to going to trial.
Now, what are officers trained to look for when a person is driving?
So what they're technically told to look for would be any kind of driving violation. So they're looking for, are they speeding? Is their equipment malfunctioning? Are they following too closely? But your narcotics guys and your task force guys look for other things.
Like what?
They look for a bunch of air fresheners hanging off the thing. Not a reason why they can stop, but it's what they do.
Right.
They look for 4 guys riding around with hats on at night. Okay? They look for multiple people in the car. They look for the windows being rolled down and people smoking in the car, because smokers are more likely to be drinkers. Smokers are also more likely to be drug users. And then they just look for, they profile people a lot. They can't say they're profiling them, but they do. Okay. So if you're riding around and you got the tailpipes that's, that are loud, and you're playing the loud music, and you got your windows rolled down, you got the lights under your car, you probably increased your chances of getting stopped from just Granny, who's one person in the car. And then, of course, as we get later on into the evening, I call it fishing expeditions.
Okay.
When we get into that 1 o'clock to 3 o'clock or 4 o'clock in the morning stage where people are leaving the bars, and that's when they're just pulling over as many people as possible for whatever reason they can see, because they want to get in there and see if you've been drinking. They want to get in there and see if they smell marijuana. They want to try to get inside your car.
Because really nothing is good going on at 4 o'clock.
Well, that's what my mama said. After 10 o'clock, nothing good's going on.
Nothing good is going on.
And so that's what they're doing.
So they can't just pull you over because you look suspicious.
Not supposed to, right? But I had an officer one time that was at a stoplight, looked over, saw the guy was sitting there with his window down, had his cigarette hanging out of his mouth and had a long ash on it, and looked like he had his eyes closed, and he stopped him for that.
Because he looked like he was driving.
And he said, based on his training and experience, he could tell from looking into the car that person was intoxicated because he hadn't flicked his ash.
Because he hadn't flicked his ash.
Right.
Wow. I thought you were going to tell me that he pulled him over just for a safety check because it looked like he was tired. That seems to me like a better reason to.
Well, the problem with that case was he didn't see any other manifestations. Had he seen him fail to maintain lane or sit at the little red light too long after it turned green, but the only thing he saw was that, and he was honest, the officer was honest about it and said that's why he stopped him. And the judge agreed that was cool. And,
that was okay?
Yeah, and luckily we handled the case and it worked out, but that was definitely something we were going to appeal if we had to. Yeah.
Interesting. So what is your definition? Here's question number. What is your definition of beyond a reasonable doubt?
I think if people really understood beyond a reasonable doubt, you'd never get a criminal conviction.
Really?
Right. I think anytime the jury goes back there and they're talking and they can't figure out something and they can't agree and unless you just really feel like the state has removed, it's not a mathematical certainty, okay, but removed any doubt of any possible defenses that they haven't cleared up, that should be a reasonable doubt. However, I think what juries really do is they want you to prove your client not guilty, right? Unfortunately, but reasonable doubt is just the doubt of a fair and impartial mind seeking the truth. It's not beyond a reasonable doubt. It's not it's not beyond a mathematical certainty. It's just
not beyond a shadow of a doubt.
Yeah, it's just a doubt that you have. And I think juries get hung up on that. I think if you can really explain reasonable doubt to people and say, hey, and one thing I tell them, if y'all go back there and y'all are talking about this and arguing for 4 or 5 hours, that's a reasonable doubt.
But if you can't make up your mind immediately,
right,
there has to be some
then the state hasn't removed all doubts. Now, they're supposed to work out a unanimous verdict, and they're supposed to talk about it. And if it's a doubt for some reason that they can't give an argument for, they're supposed to give that up, right? But if it's a doubt that they have an argument for, the other side's supposed to listen to it and pay attention to it. But people go back there and vote with their gut, I think, most of the time.
Now, do you talk to the jury afterwards and ask them, like, how did you make your decision about this?
I do. We had a hung jury recently where one girl was our holdout. It was everybody wanted to vote not guilty and one guilty. And she said, her thing was if the girl said it happened, even though there was all these other factors that showed it didn't happen. And she just hung on to that. And it's goes back to just her gut feeling. She wasn't going to let it go, and she hung the whole jury over it.
Oh, wow.
Right.
Interesting. Now, we talked about court appearances, but like, what is a grand jury, and why do I not get to be there in a court appearance if there is a grand jury?
So if there's a grand jury that meets, so the grand jury meets, I think 4 times a year. It's 23 people that sit down and hear the case. They only hear from the prosecutor and the officer. You only get to be there if you're a police officer who was charged with something. Other than that, nobody else gets to appear at the grand jury and testify. And so the prosecution presents the case. The officer may testify at there, and then the grand jury votes. The joke with criminal defense attorneys is they can indict a ham sandwich. They want the case to get indicted and charged, they can because they're presenting it, and we don't get to put up any argument to it. People get very frustrated because they have to wait for the grand jury to hear their case, and then they don't get to go, and then surprise, you get something in the mail that says you were indicted or you were not, or there was no bill.
So can't the prosecutor just decide without the grand jury to prosecute the case?
They can, but a lot of times they'll use the grand jury as a way to throw out a case they don't like. So we try to get to the grand jury, or we try to get to the DA's office before they go to grand jury. Say, look, we got this, and this. These are the issues we have. And then they can go into the grand jury and say, look, this is kind of an okay case, but we don't really think it was that good. And here's the reason why we don't. What do y'all want to do?
Y'all make up your mind.
Y'all make up your mind. They're like, no bill. Case gets no bill and sent back. And then they're like, oh, my case got dismissed, right?
But you didn't do it. The grand jury.
The grand jury did it. Grand jury handled it. And sometimes you'll, send stuff to the investigator and send letters to the investigator and send reports to the investigator. So that way he has to put it in his grand jury file, in his investigation file. And he should present some of that to the grand jury. And that kind of helps to get rid of a case or nip it in the bud before it even gets started.
Okay. So like the circumstance that would come up in is like, the boyfriend
right.
is suspected of maybe hurting or injuring the girlfriend's child. That's not his child.
Right.
Right. And so the police are thinking, oh, this child was hurt. Probably boyfriend did it.
Right.
And so the police are thinking they think that he really did. And they go to the police go to the prosecutor. The prosecutor says, yeah, I don't know. Doesn't look like the kid was injured.
Right.
Right. It looks to me like, the boyfriend gets along with the girlfriend, likes the child, right? There's no history of problems. And of course, the prosecutor knows that because you, the criminal defense attorney, have come to him.
Right.
Say, look, there's 5 affidavits from all the family members say he treats the child like it's his own child.
Well, it's normally this different situation. It's normally that the allegations have been brought up by the father of the child.
Yeah.
And this is the new boyfriend's
Mm-hmm.
and the baby mama. And so he's like, they came there and had bruises all over his legs.
Right.
And so you let
Doesn't
him know.
matter that he was playing Little League and had bruises on his legs because he was sliding into home.
And so you let the prosecution know, look, this case has been in litigation over custody for the last 4 years.
Right.
You're
bringing this to the prosecutor.
Right. They've been in court multiple times.
Yeah.
Because he wants custody of this kid because he's having to pay her $3,000 a month in child support, and he doesn't think he should.
There's all these ulterior motives.
Right. And, and here's what happened, and here's how the injury happened. And
so the prosecutor is in this position where he's saying, I don't know what to do with this. Put all this stuff in front of a grand jury, and whatever they say, they say.
Right. And then they get to go to the victim's family and the dad of the child and say, look, the grand jury didn't indict. There's nothing I can do.
Right.
We tried. We presented it to the grand
jury. They looked
jury.
at all this, and they didn't think there was enough charges to warrant prosecuting.
Yeah.
Yeah. Okay. All right. Last question.
All right.
What are my rights if I've been arrested? And, this is a two-sided question.
All right.
And if I assert my rights, am I still going to get arrested? To me, even as a lawyer, I want to know that. Like, what I know, I have the right to remain silent.
Right.
But I also, can they still arrest me?
So, and we get that a lot because there's all the TikTok lawyers and everything online about
shut up. Don't
right?
say anything.
And I agree. You should, if you've committed a crime, you should not talk to law enforcement.
Even if it just looks like you committed a crime.
Yeah, you should remain silent. But what will happen a lot of times is they get stopped and the officer comes up, license and registration.
And you don't say anything.
And they don't say anything, right?
I mean, you have the duty to identify yourself.
So once you've been stopped at a traffic stop, you got to give them your license identification. Now, if I've got a dead body in the trunk, I'd probably just keep my hands on the steering wheel and not say anything to anybody. I wouldn't even give them my license or registration, right? But if I'm just driving, I'm getting a speeding ticket and you don't hand them your license and registration, then you're forcing that officer to have to arrest you for that speeding ticket, take you down, book you in, do a photo so he can figure out who you are.
Instead of just giving you
instead
a
of just signing the bottom of the ticket saying, yeah, that's me. I'm not agreeing that I did this speeding, but it says at the bottom, in lieu of jail, I'm agreeing to come to court. And in lieu of a bond, I'm just going to sign my signature. And then you can go on your merry way. If you keep your hands on the steering wheel and refuse, then he's got to take you to jail for that. And then a lot of officers get confused about the law and you're remaining silent and they'll charge you with obstruction on top of that, right?
Because what?
Because you didn't talk to him and you impeded his
investigation of
right?
something. Yeah. Right.
So you really need to say, I choose to remain silent. Okay.
Hey, my name's Bob.
Yeah.
Here's my license.
This is what I'm required to give you. I don't want to talk about my day. I choose to remain silent. If they keep question you, where you been? Where are you coming from? I don't want to talk about that.
Yeah.
Right.
I'm not in a talking mood.
Yeah.
Sorry, guys.
Not going to talk about it. But if you're an asshole to him, he's going to be an asshole to you.
We've seen that.
Yeah. And so it's going to escalate, because then it becomes a pissing contest a little bit. He's like, oh, I got the gun and the badge and you don't. And you may be right that you have a right to remain silent.
But I'm going to ruin your day.
But I'm going to put you in jail overnight.
Yeah.
And then when you refuse to get out of the car, I'm going to knock the window open and I'm going to drag you out of that car.
Yeah.
Right? Because there's a difference in between a request and a lawful command. You're under arrest now for speeding. I need you to get out of the car. And you go, no, you can't arrest me. They're pulling you out the window.
They're going to pull you out because you're already, they've verbally told you you're under arrest.
Right. Do you mind stepping back here for me? I'd rather not. Sir, get out of the car now.
No. All right. So last thing.
Yes.
Right. I already said last thing, but you should know by now, never trust a lawyer who says last question.
That's right.
So there's this scenario.
Yes.
Right. Jim is driving along the highway with his brother, Joe. And they get pulled over by the police. And the police ask Jim, the driver, to get out of the car and to stand next to the police cruiser.
Right.
While they go talk to the brother, Joe.
Right.
Right. And
because they're trained to separate them.
They're trained to separate them. But in the meantime, far as I know, Jim was not placed under arrest for anything. They did put him in handcuffs,
right,
and stood him next to the cruiser.
Right.
I guess just to make sure that he didn't do wild gesticulating things with his arms or whatever. They go talk to Joe on the passenger side. As they're talking to Joe, Joe jumps across to the driver's side and hauls off.
Okay. Right.
Right. In the meantime, Jim is just standing there
with his handcuffs
on in front of the police cruiser, and the police officer standing next to him, body check, does a WWE body check, suplex, knocks him out of the way, knocks him clean out of his his slip-ons.
Right.
Right. And he's laying there on the ground. The police cruiser zips off and goes after Joe. Right. Let's talk about the criminal parts of that scenario. One, should Jim have been under arrest at all?
You talk about the driver.
The original driver.
Yeah.
Not the escapee.
They call that a detention, and they say they put the handcuffs on for officer safety. As a criminal defense attorney, I argue that's arrest. Okay, lights are on.
There is an argument?
Yeah, lights are on. He's got the gun on his side.
I would just have assumed that is arrest.
Yeah, he's under arrest. They argue it's just an investigative detention, just holding him. That is for officer safety,
That's for safety purposes.
Right? Not under arrest until I say he's under arrest. Some officers will leave them out of handcuffs and have them stand back there, and then the minute they find something in the car, they'll grab their gun get on the mother ground,
Yeah.
You're under arrest, that type of thing.
But I mean, that can be to be fair
right,
to the police, that can be a tense situation.
Right.
You're pulling somebody over, you don't know what's in their car, you don't know what they have. You ask the driver to get out so you can whatever, right?
I've had them even put them in handcuffs, set them in the patrol car in the back seat, close the door
for their own safety,
and say, that's not an arrest, that was just for my safety.
Well, in this circumstance, in this circumstance, it would have been a safer place for Jim to be than standing in front of the cruiser.
Right.
Okay.
But I think that's an arrest.
Okay.
You're not free to. You're not free to go. You're not free to leave.
Okay.
And you got to have a reason to arrest him at that point. There should have been some reason to arrest him instead of just
arresting Jim.
Right. Okay. Instead of I'm just gonna put you in handcuffs so I can go talk to your passenger. Right. There's really nothing to talk to the passenger about in that scenario, especially if you just stop them for speeding or stop
Yeah,
them.
I don't think that there was any discussion about why they had pulled him over in the first place.
And I think officers make a huge mistake when they don't articulate what they're doing. I think it's confusing for the person involved. It's very confusing later on. But the reason why they don't like to articulate is because sometimes they don't know.
Right.
And sometimes
Now, I
they're
haven't
gonna
made enough up.
right.
I really pulled you over because you look suspicious.
Right. I'm going to go get my code book. I'm going to find something.
I pulled you over for that broken tail that you have, right?
But the other guy jumping in the passenger seat and driving off,
There's nothing illegal about
he
that.
hasn't been placed under arrest.
That's right. Yeah.
I don't know if he has authority to drive that car or not.
Neither did the police, though.
Right. And if he hasn't been told he's being detained, then he's free to leave.
Right. And if he happens to do it at a high rate of speed, well,
then
maybe you were speeding.
Then there could be some speeding and some other stuff. I mean, you're going to guarantee the police are going to jump in the car and
chase after you.
Right. Because there are some case laws that say, like, if I see somebody running away from me or I see somebody speeding off to get away from me, then that's a reason for
an
me
articulable suspicion
that some kind of criminal activity happened. But if I leisurely scoot over into the driver's seat, put it in drive and drive off,
technically you haven't done anything wrong. Yeah.
Now I may have been, they're probably going to charge you with obstruction because he was investigating other particular crimes, and I'm sure he's going to say he smelled marijuana or something in the car.
Yeah.
But if he would just say, "Hey guys, need you to step out here. I'm going to put some cuffs on you." And then when he gets back here to the car, he says, "Hey, I smelled some weed in your car. Can I search your car?" And the guy goes, "No, you can't search my car." He's like, "All right, well, I might have to get your passenger out because I got to get a dog over here to run around your car."
Right.
Or go tell the passenger, "Hey, passenger, I need you to stay in the car because I got a canine coming." Then I think he's fine. And then the officers told him, "Hey, I'm investigating. This is an open investigation." Then he can't hop over in that seat and leave. He's affected.
But I mean, isn't there a point though where the officers are detaining him for too long?
Absolutely.
Where is that point?
We don't know.
I know. You will catch that on the next episode of Bob and Irreverent D Talk Law. Thank you for joining us. What fascinating discussion about criminal defense things. Thanks for joining us. Make sure you subscribe, like our video, and tell everybody else to watch us.
Thanks for listening. Tune in next time when Bob and Irreverent D talk law.